She sued her best friend for destroying their daycare with one post. A single Instagram post cost one woman her business, or at least, that's what she wanted the court to believe. For 11 years, the two women had been inseparable. They met in a child development program at a community college, bonded over shared dreams of running a place where working parents could feel genuinely safe leaving their children, and by the spring of what would become their defining year, they had built Sunflower Steps Learning Center into one of the most respected small daycares in their county. 42 enrolled children, a wait list, a reputation built on birthday boards, gentle redirection, and handwritten monthly progress notes that parents framed on refrigerators. Then, in March, the partnership dissolved. It wasn't clean. The co-founder, the plaintiff, was bought out of her equity stake for $47,000, a figure she signed off on, a figure her own attorney reviewed. She left. The daycare stayed open under the sole ownership of the defendant, her former business partner and closest friend. 3 weeks after the buyout was finalized, the daycare's Instagram account posted a photograph. It showed the front entrance of Sunflower Steps, freshly repainted with a caption that read, "New chapter, same love. We chose integrity when it was hard and our families noticed. Thank you for staying." The post received over 400 comments. Parents flooded the replies with support. Some mentioned they'd heard things. Some thanked the owner for protecting the children. The plaintiff claimed she didn't need to read between the lines. She said the entire county did it for her. Within days, former colleagues were calling to ask if she was okay. A parent at a competing daycare told her directly, "I heard you were asked to leave because of how you handled the kids." The plaintiff filed suit seeking $85,000 in compensatory damages and $40,000 in punitive damages, arguing the post constituted defamation per se, a statement so inherently damaging that harm could be presumed without proof. Her attorney argued the phrase, "chose integrity when it was hard," was a deliberate, thinly veiled accusation of misconduct, specifically targeted at a woman who had just left the business and who the community would naturally identify as the subject. She took the stand with composure and genuine pain. She described turning down 2 job offers because prospective employers had seen the post. She described her daughter asking why people were saying bad things about her mom. The jury leaned forward. The defendant's attorney was calm and methodical. He submitted the post into evidence and asked a simple question: where, in this caption, did it name anyone? Where did it accuse anyone of anything? He called it what he said it was: a celebratory statement from a small business owner who had been through a difficult transition and wanted her community to know the center was thriving. But he argued that the plaintiff was retrofitting meaning onto language that was intentionally vague, and, more importantly, that the alleged reputational damage had a far more traceable source. Then came the deposition transcript. During discovery, the defendant's legal team had obtained text messages between the plaintiff and a mutual friend sent in the 2 weeks before the Instagram post went live. In them, the plaintiff had written that she intended to make sure people knew why she really left. She had told the same friend that the buyout was extortion dressed up in legal language, and that she planned to speak to parents directly. Cross-referencing phone records, the defendant's attorney demonstrated that the plaintiff had personally contacted 7 current Sunflower Steps families in the days before the post was published. The rumors that spread through the community, the ones the plaintiff blamed on the Instagram caption, had, in measurable part, originated with her own phone calls. The judge allowed the jury 40 minutes of deliberation. They came back in 32. The plaintiff was awarded $400, enough to cover documented lost wages from one canceled consulting engagement where the client had specifically cited the Instagram post in writing. Everything else was denied. The punitive damages were thrown out entirely. The judge, in his closing remarks, noted that the plaintiff had entered the courtroom as the victim of a story she had largely written herself. The defendant did not celebrate publicly. The Instagram post, notably, was never taken down. The plaintiff appealed the inadequacy of the damages award 4 months later. That appeal was denied. Sunflower Steps is still open. The wait list is longer than ever. Here's what this case leaves unresolved. If you start a fire and someone else hands you a match, who burned the house down?